There we go. Okay, the recording button has started. So we are officially ready to go. This is the special setting left over from the March 7th docket that was sitting in Wichita. We have a special setting for case number 124882, Jones v. Kansas. And it looks like we have counsel for the parties here. Can appellant please state their name?
Yes, Your Honor. Appellant Austin Jones appears by counsel, Wendy Miller by Zoom.
And Ms. Miller, is that how is it W-E-N-D-I-E?
Yes, ma'am.
And the state? Can you state your appearance? Oh, well, we can't hear
You're
you.
muted.
Tested this.
May it please the court.
Ah, yes.
Assistant District Attorney Lance Gillette on behalf of the state of Kansas, present, ready for argument.
Thank you. All right. Well, thank you all for agreeing to be here today. It doesn't look like we've awarded any extra time. Would appellant like to reserve time?
Yes, Your Honor. I would like to reserve 2 minutes for rebuttal, please.
Okay. That is granted. We might ask you questions throughout. We will be equitable with the time. Should we take up a lot of your time with our questions? Anything else before we get started? Right? Appellant, please go ahead.
Yes.
I'm sorry, I do have one question. At our hearing last week, when we continued this matter, Mr. Gillette said that he wanted to make a concession. And I thought maybe it might be better to address that concession up front for the benefit of the appellant here. Do either of you have an objection to doing that?
I was planning to do that in my argument, Your Honor. Frankly, it's not a substantive concession. It's just a procedural point that I wanted to make sure I noted.
Okay. Well, do you think it would be beneficial for the appellant to know before we proceed with her argument?
I mean, I can save them some time. It's regarding the timeliness, my timeliness arguments for Mr. Miller's filing. There were 2 Kansas Supreme Court administrative orders in place that could have potentially made that timely. So it's just the timeliness argument that I'm not advancing any further.
So you're saying is action is timely?
I'm only saying it's time. It could have been timely. Yes.
Okay. Thank you.
Thank you.
All right. I think, thank you, Judge Schroeder. Also, I think I neglected to introduce my colleagues, Judge Bruns and Judge Schroeder, who are here. I'm Judge Hurst. Okay, we will start over. Ms. Miller, can you please begin with your argument?
Yes, ma'am. Central to the issue today, I believe, is that whether or not appellate 1507 counsel was ineffective for failing to raise issues on appeal. And in considering that, everybody's going to have to take a look at the detached memo. It was a pro se document filed by appellant. So hopefully my argument will address any questions that the court might have over it. Mr. Jones had filed a 1507. His original 1507 had raised that the trial court had misstated facts at sentencing. He had raised the issue of fabrication of evidence and contamination of the crime scene. He had raised the issue that state witnesses lied under oath and that defense counsel did not assert immunity or failed to investigate self-defense and failed to subpoena a witness who would corroborate his self-defense claim. So this particular 1507, there were 13 issues raised. The questions that are central to this appeal, I believe, are whether Appellate 1507 was ineffective for failing to raise issues on appeal. And we have Bellamy versus State without making factual findings as to counsel's advice to his client. There's no way to determine whether the district court's factual findings are supported by substantial competent evidence. So we're arguing that Mr. Jones should have received a full evidentiary hearing on his issues in his second 1507 with regard to whether Attorney Patty failed to raise issues on appeal. As far as one of the issues that the district court had granted a Lujan hearing or a preliminary hearing to determine whether there was a substantial issue of fact, the assertion was that Ms. Patty failed to raise and argue all issues raised in Mr. Jones' petition that were denied by the district court. Ms. Patty had argued that the district court failed to appoint counsel and that Attorney Brown was ineffective in failing to raise the immunity issue, which required an evidentiary hearing, and that the district court failed to make findings of fact and conclusion of law on all of petitioner's claims under Rule 183J.
Counsel, aren't those arguments that you're expressing trial related errors, and that they should have been addressed on direct appeal, and some of those were actually addressed by our court and also the Supreme Court?
Well, the Supreme Court did address the immunity issue, the ineffective counsel claims, and certainly whether or not Attorney Patty was ineffective for failing to raise issues that had not been addressed previously. And some of my argument, I hope, kind of ferrets out, what the difference is in the claims here. But one of the issues that Mr. Jones claims that Ms. Patty failed to raise was the failure to subpoena a witness, and that this court actually found that issue had been abandoned, that issue wasn't briefed. And so the argument is that Patty's failure to raise judicial misconduct, prosecutor misconduct, introduction of perjured testimony, and ineffective counsel based on trial counsel's inadequate knowledge of the law or preparation and failure to subpoena a witness to corroborate Mr. Jones's claim of self-defense was ineffective. This court ruled that Patty's failure to raise the judicial misconduct preclusion of evidence claim, that the issue could have been raised on direct appeal, and Jones provided no exceptional circumstances to excuse this failure. Now, with regard to Patty's failure to raise the claim, she had indicated in a letter that was dated May 19th, 2016, and this is part of the record, that Mr. Jones's notice of appeal was limited to the immunity issue, and that he failed to file a notice of appeal after the district court's January 14th ruling. And so that acted to forfeit his claims of judicial misconduct and the prosecutor misconduct and perjured testimony. But if you look at the notice of appeal, if you look at the language that Mr. Jones used, he filed his pro se notice, and it stated, comes now the petitioner Austin Jones, pro se, moves this court to permit the petitioner to file this formal notice of appeal on the denial of the petitioner's 1507 petition. The notice actually then goes into the specifics of the immunity issue. But if we construe his pro se notice of appeal liberally under Bruner, and under, I think we cited the case Key versus Hine, that pro se notices are liberally construed when the notice contains a catch-all provision. And that's what I think Mr. Jones, if you look at the language of the notice, he was appealing the denial. He wasn't just appealing part of the issues, and he couldn't file the notice of appeal until everything was final, because he can't appeal something where there's not a final judgment. So her conclusion, Patty's conclusion, that he forfeited his claims because he didn't file a notice of appeal after the partial ruling on January 14th, we contend was error, and that a final decision has to dispose of the entire merits of the case and leave no further questions. So the motion minute sheet from March 16th, 2015 would have been the order that disposed of all claims. So then his April 16 notice of appeal was filed within 30 days of the final judgment and then was timely. So then with regard to the detached memo, well, what is this document and how should it be considered? Attorney Patty indicated to Mr. Jones, and I believe this is in her letter that's part of the record. She told Mr. Jones that he filed this way too late for anything in it to be useful, to argue that the district court should have been reversed for any reason, in that our position is that the detached memo could be construed as a motion to reconsider or a motion to alter amend under 259F, or it could be considered as an attempt to amend his petition. I think when I look at the detached memo and the arguments in the detached memo, that they follow along with the issues that he raised in his petition generally. It's not uncommon for somebody that's filing a 1507 petition, and that's whether they're represented by counsel or whether they're pro se, to file their initial petition. And then once that petition is on file, to submit a separate memorandum. In this case, it looks like the memorandum and the judge's final order and the motion minute sheet kind of crisscrossed each other. So when he filed his detached memorandum, he didn't realize that his petition had already been decided. But if since it was filed after, I guess, the decision, then it could be considered as a motion to reconsider. Part of the reason why the district court denied Mr. Jones's claims is because they were conclusive. And I think that the detached memorandum fully expounds upon the issues that he raised. One of the things that we assert that Ms. Patty should have done is ask for a remand from you all so that the district court could consider the claims in this detached memo and make that decision. Because we don't have a district court ruling on that detached memo, and our position is it should have been considered. And whether it was a supplemental memo that was in support of his 1507, whether it was a motion to reconsider, or whether it was an application to amend his 1507 petition, we think that this case should be remanded for the court to consider that the issues that are raised in the detached memo. And so with the judicial misconduct claim, it's, I guess, evidence preclusion is what it's been.
Counsel?
Yes.
I guess I'm a little confused. What issues in the memo are you alleging are not direct trial errors that should have been addressed on appeal, in the direct appeal?
Well, So certainly, whether Attorney Patty was ineffective for raising issues.
No. You're talking, aren't you talking, she was the 1507 first counsel, right?
Right.
I'm talking about what issues in his motion are errors that could not have been raised in his direct appeal on his conviction.
I guess I'm maybe mixing up the two petitions, but as I understand it, the second 1507 and what was set for an evidentiary hearing, or what was set for a Lujan hearing, was the issues 10 and 11 from his second motion. And that had to do with Patty's failure to raise issues. And some of those issues are intertwined with whether or not trial counsel or appellate direct appeal counsel were ineffective for not raising issues. And so if you look at the detached memorandum, he does discuss ineffective trial counsel, and I believe effective appellate counsel. But so it's everything kind of mixes together here. But the main thing is, we think he should have gotten an evidentiary hearing on whether Attorney Patty was ineffective for failing to raise these issues. And one of the issues was the judicial misconduct issue. And our position is that the claim was based on part. The court erred in ruling that Jones's knowledge of Delatorre's arrest for domestic violence was not relevant to his claim of self-defense. The ineffective assistance of trial counsel claim is that when the state moved for a motion in limine to prohibit Delatorre's arrest from coming, that Attorney Brown didn't have any objection. And then denying the 1507, the court found that the first claim of preclusion of evidence should have been raised on direct appeal, and there were no exceptional circumstances because Jones testified, and then he was able to present his state of mind, and the victim's arrest was just bootstrapping of the claim, and that it was also excluded for independent reasons. And then in our brief, we've made the argument that Delatorre's arrest was relevant to Jones's state of mind and the subjective prong of his self-defense claim, and that under Walters, the Walters decision, where the court indicated that the defendant's knowledge of the victim's standoff with police 2 months before the defendant killed the victim was relevant to his state of mind at the time of the killing. And the standoff was not being introduced to show the bad character of the victim, but Walter's state of mind at the time of shooting, which is similar to what was, why the evidence should have come in here, or why trial counsel should have, made an objection at the time that the state was arguing to the motion in limine.
Counsel, let me ask something here. I'm looking at your statement of issues in the brief, and it looks like, I know he raised 13 issues in this supplemental pleading, or whatever we want to call it, that he filed after the judge had evidently already ruled on his motion. But the 4, each of those is appellate counsel was ineffective. Appellate counsel was ineffective. So I take it, at least in the brief, that kind of drop the direct challenge to trial errors, perhaps because of Judge Schroeder's question about that. But it does look like those 4 issues, each of them, well, 3 of the 4 involve things that trial counsel didn't do. And then the first one involves this judicial misconduct claim. So even though it's phrased as appellate counsel, it seems like these all go back to errors that were committed at the trial, if they were committed at all. What's your thoughts on that?
Well, and I think what makes the claim new again is that these are claims that should have been asserted by Appellate 1507 counsel. So Appellate 1507 counsel would be making claims of ineffective assistance of counsel based on arguments that were made in Mr. Jones's detached memorandum, and then also what his claims were as stated in his 1507 petition. So, but I'm sorry.
Sorry, counsel, you have gone over your time. If you want to take 30 seconds or a minute to wrap up, that would be great.
Sure, and then I just wanted to say that yes, I understand that the Kansas Supreme Court has decided the immunity issue, but then I wanted to direct the court's attention, and I think it's the Phillips decision that we cited, where the Kansas Supreme Court, and this decision obviously came after Jones, but the Kansas Supreme Court rejected that harmless error analysis is always appropriate in the context of an error occurring during an immunity hearing, simply because the jury returned a guilty verdict. So an immunity error does not implicate the verdict. And so I just wanted to point out that distinction. And we've cited Phillips in our brief and asked the court to review that issue as well.
Thank you, counsel. Any other questions before we move on to the state?
No.
All right, Mr. Gillette.
Thank you. May it please the court. I'm going to circle back and just very briefly touch on the point that I wanted to clear up. It was at pages 20 to 24 of my brief. I made the argument regarding timeliness of Mr. Miller's memorandum of law in support of a Lujan hearing. And it was an oversight on my part. We could even call it COVID brain. This is a process, and there were a lot of rules in place at times that varied. And I simply appear to have made an oversight. And I would specifically point the court to Administrative Order 2020 PR 47 that suspended all time requirements beginning May 1st of 2020. And then Administrative Order 2021 PR 100 that did not resume filing deadlines for 1507s until August 2nd of 2021. That is the only concession, though, that I want to make at this point, because what the state is continuing to encounter here is a constantly moving target. It is a problem that the district court struggled with, and it seems to be an issue that this court may have some issues with this morning as well. Regarding Mr. Miller's memorandum of law in support of a Lujan hearing, that is the first time that this detached memorandum is ever raised. When Mr. Jones filed his second 1507 petition, which we are here before the court on today, he made no reference to it at all. And so perhaps seeing the writing on the wall, and that the majority of these claims, as the court I think has astutely noted, were trial error issues that either were or could have and should have been raised on a direct appeal. Then we have counsel entering this memorandum where basically every claim is recast in the light of this detached memorandum, because somehow, some way, this document is supposed to be the key. To that end, I do not believe that counsel's attempt to make these amendments is procedurally sound. Despite being potentially timely, there are two things that I wanted to touch on. Here, the district court entered a very specific order on May 29th of 2020. As appellate counsel that's here today noted, this case started with 13 issues. This order in May of 2020 narrowed it to two very specific issues. Claims 10 and 11 from that original filing, and those dealt with only two things, and that was his challenge to how Miss Patty, his attorney on the first 1507, handled his petition for writ of habeas corpus. Again, no mention of any detached memorandum. And then 11 was the immunity issue, or no, excuse me, not subpoenaing a witness. That was all that was before the district court at that point. And so going outside of the bounds of that order would require some further affirmative step or act or finding by the court. And there is none here. What we do see is a memorandum that's filed, but there is no right. The defendant had no right to amend his 1507. In fact, doing so would have required Mr. Miller to seek leave of the court to do it, pursuant to KSA 60-215C and the Thompson case that I cited in my brief where they discussed Pabst. He failed to do so. Had he, the court could have potentially considered amendment because it is a matter of discretion. It would have still required relation back. And I think that we're definitely in the hypothetical world now, but finding relation back to the claims brought in defendant's second 1507 based on a document that was filed years prior seems like a very difficult hurdle for any reasonable person to clear. With that said, if there are no other questions, I would just move on to the issues that were presented briefly. There were several questions today. Actually, forgive me. There was one other procedural point, and I mentioned that there's a constantly moving target here. I heard again, for the first time, I'm fairly certain today that no, this detached memorandum shouldn't have been considered a motion to reconsider, nor should it have been, it could have also been considered as a motion to alter or amend, or for the first time, perhaps it was an attempt to amend his petition. A couple things. It couldn't have been a motion to reconsider, and I address this in my brief. He didn't have the district court's final order. It couldn't have been a motion to reconsider, nor could it have been a motion to alter or amend. Again, because the defendant did not have the court's ruling to seek an alteration to. And so again, for the first time, now we hear, well, maybe it could have been an attempt to amend the petition. Maybes and could have and should have do not amount to error, and they should not be claims that are being presented to this court for the very first time. So there were several questions about the substance, and that's what I'm going to shift to now of these claims. The first that I heard from Judge Schroeder is that what's in this detached memorandum that wouldn't have been subject matter for a direct appeal? And my answer to you, Your Honor, is nothing. There's nothing in there. There's nothing about these claims. There's nothing about the detached memorandum that is some special magical wand that would allow us to go back in time and completely rehash, reconfigure claims that were made. There's nothing. So in defendant's first 1507, he raised the judicial misconduct issue, which was that trial counsel misstated a fact, or the trial court misstated a fact at sentencing. I would note that while he made that claim, the claim was revised and to become this issue about one of his murder victims' prior arrest for domestic violence. I want to talk about this one briefly because I will acknowledge that the confusing, constantly moving target nature of these claims led the district court and the state a bit astray on this first issue. Because again, his only claim from the first 1507 that he wanted to fault Patty for not advancing was judicial misconduct, that the district court misstated facts that were used to enhance his sentence. The district court, and regrettably even the state, was misled by the memorandum in this instance. And that claim morphed to become the issue about the domestic violence arrest and the vague allowance of false testimony by a prosecution witness. I would urge this court to focus exclusively on the claim that was originally made. And the basis for that is that this court can uphold the district court's ruling, even if it's right for the wrong reason. The district court was right to have rejected the movement's first claim, even though it was led down a primrose path. In the alternative on this claim alone, even if this revised or rehashed claim were to be considered, it is, I don't know how else to say it, it is meritless and confusing. It doesn't make sense to the state why we want to try to say, why anyone would say that the connection to a prior domestic violence arrest would be such a would be some kind of a linchpin here, particularly when in this case, what was before this jury was the fact were facts that Delatorre, the one murder victim, was upset and had threatened to whip the movement's ass. That was in evidence, as was a reference to Delatorre and the girlfriend splitting following a, quote, domestic dispute, end quote. I don't understand what an arrest would change about that. And I don't think that it's actually ever articulated by movement either, because it simply wouldn't. But even if we were to assume there could have been some minuscule difference here, there's the fact that it is so minuscule just emphasizes that there could have been absolutely no prejudice here.
Counsel,
yes.
Counsel. So if I understand correctly, the appellant is arguing that it was judicial misconduct for the court to rule that certain evidence wasn't admissible?
That is what the claim has become, yes.
But that is in itself a trial error.
That is indeed.
All right.
And that was going to be my next point. This is a trial error. Was never any exceptional circumstance offered for why this wasn't raised on a direct appeal, nor was there any argument made for why this wasn't even actually a claim in his first 1507. The detached memorandum isn't even perfectly clear on this particular issue. If there are no other questions about that point, I'll proceed to the second claim was that Patty was ineffective for not pressing his second claim from his first 1507 on appeal, which was an allegation of prosecutorial misconduct, which again is a claim that is subject to direct appeal review, and that's where it's supposed to be brought. In this case, defendant did bring claims of prosecutorial error on his direct appeal. And in the second 1507, this court deemed additional claims like this, whatever it may be, waived because he failed to raise it in his first direct appeal. At this point, frankly, nothing more really needs to be said. That it was again a trial error that should have been raised on a direct appeal, wasn't it? And it just is not grounds for any kind of a relief here. Some denial was appropriate. Turning to the third claim from his first 1507, that claim was simply that the state introduced perjured testimony. The claim was then revised to become that Patty apparently should have done something more regarding Johnny Nash's testimony. Again, we're talking about claims about trial error, potentially about an ineffective assistance claim of trial counsel, but not about a claim against Patty, a 1507 counsel. I would also note that this claim originally dealt with another witness, Jessica Vestering. Movement has abandoned any kind of a claim against or about her testimony whatsoever. And then regarding Nash, it was perfectly clear on this record that Nash understood that one of the eventual victims, Delatorre, was mad at the movement. There were conversations about whipping his ass. There was also testimony from him that, quote, "we fight amongst each other." That is what these folks did. So again, it's completely unclear what harm or what benefit there would have been here by going further into Nash's testimony. Again, he did testify. He was subject to cross-examination. I have not seen anything clearly identifying what more he should have been pressed about or asked about, and nothing appears on the face of the record. So frankly, the conclusion to this point is that Patty had no duty to challenge the jury's credibility findings in her work on his first 1507. She had no basis to challenge anything about Nash that wasn't raised in the direct appeal. And there certainly could have been no prejudice, even if one were to assume Patty had been ineffective in not pushing this baseless attempt to have our appellate courts reweigh credibility. The fourth point was that originally that trial counsel Brown was ineffective for not litigating an immunity motion. The movement then tried to revise that claim into a few more points about not pursuing statutory immunity based on things that were said in the detached memorandum. Again, I think that the district court here got it correct that, as did our Supreme Court in the direct appeal, immunity is an issue that should have and had to have been raised pre-trial, cannot be revisited. It is res judicata. And the only slight twist, I guess, that did occur here is, and there was some discussion about this subjective state of mind. Again, I don't see that clearly articulated in the defendant movement's own pleadings, but the district court's ruling to this end, again, there was plenty of evidence in the record about what his state of mind was. He testified. To try to talk about an arrest would have just been bootstrapping the underlying claim. It was in evidence that he claimed he was afraid of the man that he shot in the back of the head. That much was in evidence.
So Gillette, you are at the end of your time. However, I will give you, a minute or so to wrap up if you would like.
Okay, thank you very much, Judge.
Mhm.
Honestly, I think that the briefs pretty well handle the remainder of the remarks that I was going to make. I just would say the immunity claim obviously cannot be raised now. Patty can't be faulted for that. It simply baffles at how we have to try to continue to hit a moving target. The targets that were presented were all knocked down one by one because they were completely meritless, and Patty was not ineffective in any form or fashion. Nothing that movement tries to do here today or has tried to do repeatedly by morphing their claims can change that. So I would ask that this court uphold the district court's ruling. Thank you.
Thank you, Mr. Gillette. Ms. Miller, you have 2 minutes of rebuttal.
Just quickly with regard to the prior arrest, if you just considered whether the prior arrest should come into evidence or should not have, then it would just be a trial error. But in this case, we're saying that because it went to Jones's subjective state of mind, which is part of what you have to show to obtain immunity from prosecution, that the claim should have been raised as an ineffective assistance of counsel claim as to Attorney Brown, who didn't object to the state's motion in limine or argue the relevance of the arrest. And that's contrary to the Walters decision, where you have almost the same situation where there was a prior standoff with police a couple of months before the victim was shot. You know, the arrest is a big deal because it goes to his subjective state of mind, and it goes to the immunity issue. And the question is, you know, whether Attorney Brown was ineffective for what he did with regard to, you know, allowing the evidence to come in without objection. No objection to the motion in limine and his activities or inactions as far as pursuing a motion to dismiss or the immunity issue. And then whether, of course, overriding everything is whether Attorney Patty was ineffective for failing to raise these claims. In the detached memorandum with regard to Nash, one of the issues is whether counsel was ineffective for failing to complete the impeachment of Nash by calling Officer Stearns as a witness. And in the detached memo, Jones had cited to the report of Officer Stearns, whose report had indicated that Nash had told him that they left. Nash and Delatorre had left Quincy's house because Easy, I guess otherwise known as Delatorre, wanted to go over and check and see if Austin was there and get everything over with. At trial, Nash denied that they were going over there to get everything over with. And the comment about whipping his ass if he helped the girlfriend move, if he learned that he had helped the girlfriend move, might have been made. But it's different than his statement, Nash's statement to law enforcement prior to trial that they were going over there to get everything over with is different. And he talks about the issue in his detached memorandum that Brown didn't complete the impeachment by calling Officer Stern as a witness. He just asked Nash about it, and Nash denied, no, we weren't going over there to get everything over with. So, and that's different too. And also it goes to, you know, again, how significant the immunity issue was here and Jones's state of mind.
Thank you.
Thank you.
You have run out of your rebuttal time. Do you want to take a few seconds for a last minute sentence or two, or?
We will go ahead and submit the case, Your Honor.
Right. Well, thank you both for your time today and for being amenable to the change to a Zoom argument. We will take all of your briefs and this oral argument under consideration and get back with you as quickly as we can.
Thank you.
Thank you.
Thank you.
Thank
both.
you.